23-year-old lifeguard Zachary Stein helped save 5-year-old Adam Cuddick, who nearly drowned at a splash pool here at Chelsea Piers in Stamford, Connecticut. They arrested him for endangering the boy's life.
Zachary Stein pleaded not guilty to charges of reckless endangerment and risk of injury to a child in Stamford.
But this is a small pool, and we believe should have been noticed sooner.
He wasn't drunk, he wasn't texting, he wasn't talking to other girls or other lifeguards or other people. He was doing his job.
What's up, everybody? Welcome back to the channel. My name is Scotty O, aka the Gen Z Attorney, and I currently work as an assistant district attorney in the great state of North Carolina, meaning I'm a prosecutor and I'm in court every day and I'm working to put bad guys in jail. So focus on the criminal law and the constitutional law, and here I make videos where I go through those topics and I pull back the curtain, give you a window into the criminal justice system from the prosecutor perspective that you might not get anywhere else. In today's video, I think it's going to be a pretty quick one. It's just an interesting story that I wanted to go through with you because I've never seen anything before like it, and I think it's worth talking about. Now, today's story takes us to Stamford, Connecticut, where a lifeguard was charged for felony child endangerment as well as risk of injury to a child. Now, according to news reports of what happened that day, the lifeguard, Zachary Stein, 23 years old, was on duty. He was the only lifeguard at this pool. And as he was working, a child was underwater for over 4 minutes, and the lifeguard did not see him until after 4 minutes had elapsed, at which point he does see him and he jumps in to do the save. Now, the lifeguard does end up pulling him out and administering CPR and then ends up saving the kid's life. So I imagine he was a little surprised, a little shocked to find out that he was the one that was being arrested after these events. Now, the central question in this case is going to be very fact dependent on what the circumstances were at the time. Based on the news reporting, there were 8 kids in the pool at the time, and the pool, as far as size, was about 30 feet by 30 feet, so not very big, but also if there's a lot of people in there splashing around, that's not nothing. And so the police's theory and the prosecutor's theory in this case was almost a theory of negligence, where he should have known, he should have done a better job being on lookout, and his failure to be on a better lookout led to this child almost dying, hence the endangerment charge. Now, this raises interesting legal questions about something called the duty of care and the duty to act. When it comes to civil law and a duty to act, there generally is no duty to act. So for example, if me or you were to see a drowning child, we would not have a legal duty to act. We could not be held liable, civilly or criminally, for our failure to jump in and save the kid. Sounds dark, but you could stand right at the edge of the water, looking at the kid, watching them drown, and do nothing. Don't go get help, don't do anything. You could do literally nothing. But because you don't have a duty to act or a duty to go get help, you wouldn't face any sort of charges or repercussions whatsoever. So that's the general rule when it comes to duty to act. The exception to that rule is for people who are in positions that are expected to act. So for example, a firefighter. If there's a building on fire and a firefighter shows up, they are expected to act, and their failure to do so could render them liable for their failure to act. Now, as you can imagine, one of these positions where there would be this duty to act, and there is a duty to act, is going to be lifeguards guarding a pool. I mean, that's the reason they're there, is to guard the pool, ensure the safety of everyone inside, and if anyone were in danger, to jump in and be the first responder on the scene. But that's what makes this interesting, is the duty to act and everything that goes with that is generally a tort law, a civil law matter. This is the criminal law, and the DA here tried to put this legal doctrine into a criminal context. And this has just never been done before, which is what makes it so interesting. And we know it's never been done before because the American Lifeguard Association put out a statement stating this has never been done before. And making some very valid points, I think, about how, first off, in this case, lifeguard did his job and he saved this kid's life, A. B, this would have a huge chilling effect on the industry as a whole if you've got lifeguards now that are at risk of going to jail if they don't do a good enough job. So that's where the American Lifeguard Association is coming from, in feeling like, hey, if we have lifeguards that are in danger of going to jail if they don't do a good job, well, all that's going to do is disincentivize people from even becoming a lifeguard in the first place. And you take a case like this, yes, it took this lifeguard too long to jump in. 4 minutes, I would agree, is too long. But it's better for it to have taken 4 minutes of action than to have taken forever for action because there was no lifeguard there. But either way, he gets charged with felonies, ends up resigning from the pool where he had worked for 5 years. And now we get into the court system, the court process, and saw a statement from his defense attorney saying that he wasn't drunk, he wasn't texting, he wasn't talking to other girls or other lifeguards or other people. He was doing his job. And like I just said earlier, was he doing his job well? Maybe not. but he was still doing his job, and ultimately, in the end, did his job in a way that saved this kid's life. But what I just find so interesting about a case like this is I can think of at least 2, maybe 3 groups of people or organizations that I think bear more of a burden, bear more of a responsibility on a case like this than the lifeguard. So apparently these kids were taking a break from their summer camp, so I don't know if that means they departed from the summer camp to go to the pool or what exactly. I don't know if that means their camp counselors were with them at the pool or if it was their parents, but that's always going to be step 1 of supervising your kids. I mean, this kid, I think, was 5 years old, and if he can't swim, then lifeguard can't mind read everyone who's in the pool and assess who can swim, who can't swim. If you're a camp counselor or you're a parent and you're letting a 5-year-old who can't swim get into a pool, I think that's going to be step 1 for responsibility and liability. Step 2 could be the pool itself. I mean, it doesn't seem like the pool was too big, but to only have 1 lifeguard on duty, that could be a potentially negligent thing to do. So yeah, it just seems odd that for all the steps, all the missteps along the way, the person who is facing the most punishment, the little threat of going to jail, becoming a convicted felon, is the lifeguard, the one who actually saved the kid's life. So that's all these interesting novel issues that are kind of floating around in this case. And ultimately, Mr. Stein, the lifeguard, ended up not getting any jail time. He went into a program where basically in exchange for pleading guilty and meeting some conditions for the time after pleading guilty, he can then come back to court and the charges will be dismissed, assuming he's in compliance. In this case specifically, his probationary sentence here was basically that he's not allowed to be a lifeguard or a life-saving professional for 2 years. And after that 2-year period, he can have his charges ultimately dismissed and maybe even expunged, I'm not sure. Now this is similar to some programs that we have in North Carolina. They're called deferred prosecution agreements. Our office will usually grant them for first-time offenders that are probably young. They're conciliatory, so they know they made a mistake, and the charge is not too serious. Our office will tend to grant those deferred prosecution agreements, put some conditions on them, like, hey, gotta pay some fines, pay some costs, and maybe go get some sort of assessment or do some classes on something related to whatever the crime was. And after 6 months, assuming you're in full compliance, we'll dismiss the charge. And this even applies to, in the felony context, in North Carolina, we call them 9096s. Usually it applies to drugs, but you can get on a 9096 program that, same idea, you're pleading guilty, but then you have some conditions imposed on you, usually by getting a substance abuse assessment. And assuming you're able to get clean and stay off the drugs and do everything you're supposed to do with the conditions of probation, then the charges will be dismissed per the 9096 agreement. So that's basically what they entered into here. I think this is a fair outcome, a just outcome. I think the DAs here and the police were a little more gung-ho than I would have been in trying to throw this lifeguard in jail. And really the biggest factors for me there are going to be obviously the end result that he did save the kid's life, but also the fact that there was no evidence that he was distracted in a way that he should not have been, like being on his phone, talking to people, doing his own personal activities while tasked with being the lifeguard. Sounds like he was overlooking the kid, which if you see some of these pools, it can be quite a chaotic scene. And while that's not an excuse for how long it took to see the kid, it does offer some insight into what actually happened here, and then what's the appropriate punishment, because also as well, first-time offender, young guy, 23 at the time. What I see in court often is just people who really don't have their lives together, and because of that, they continue to make bad decision after bad decision. And these are the type of people that do need to be set straight. By the time they get to the criminal justice system, it's difficult for us to do anything to set them straight. There's a lot of steps along the way that unfortunately need to go wrong for someone to be in these types of situations. But once they get to us and you're just a habitual offender, you continue to do bad things, you continue to hurt the people around you, then yes, if you're charged with a felony, you probably need to plead to the felony. Probably need to be found guilty of it. But for a guy like this, yeah, no record, young guy, just an unfortunate situation. This is not someone I would want to see made into a convicted felon. And thankfully that's what happened here. They put him on the program and I'm assuming he complied with it and is now not a convicted felon. So that's all I've got for today. Just a quick video, something interesting, an interesting issue that I've never seen come up before. I just saw TikTok about it and thought, hey, this is something I could talk about. But let me know what you think down below. Do you think he should have been stuck with the felony? Do you think the deal they gave him was good? Do you think he shouldn't have even been charged at all? Let me know down below. Of course, as always, I'll be down there talking with you all about it. If you like this video, be sure to let me know, drop a like, and if you like this kind of content, then subscribe to come back for more. Other than that, that is all I got for today, so I will see you all on the next one.